Matter of Coalition for Fairness versus City of New York.
Good afternoon, Your Honors. May it please the Court, John Shepwong on behalf of the appellant. I'd like to reserve 3 minutes for rebuttal, if I may. Thank you. So I'd like to begin with the predicate question in this case, and that's whether the government action here can be thought of as a taking. If it can't, that ends the analysis, and the First Department completely ignored that aspect of this. And there's two reasons it's not a taking. Number one, the action challenged concerns a pre-existing undisputed restriction, and refusing to allow petitioners to remove it and to add to their bundle of rights with regarding to their property does not take anything from them.
But counsel, they're offering a benefit here, right? So if someone came in and asked for this benefit, asked for a variance on a zoning, and you put a condition on that, why is that different under Sheets than the government doing it this way?
Well, here's the difference, Your Honor. I think that what's important to remember is that there is this restriction that runs with the property. It's a specific use restriction.
And if you lift that restriction, which you can't do right now, the property increases dramatically in value. I understand that, but that underlies all of these cases. I mean, if they weren't giving a value for the condition to be posed, then why would anyone do it? So you're always increasing the value of your property by getting some benefit from the government. Here, changing the status from artist restricted to residential, let's call it.
Respectfully, I disagree, Your Honor. I think that all of the cases that have preceded this one have all concerned, none of them have concerned this type of restriction that is running with the property, that is specific to the property. All of them have concerned overarching permitting schemes where the government has a role in granting or denying permission to develop the property.
Could you grant or deny a zoning variance? If something's zoned a certain way, can you grant or deny a zoning variance?
I think a zoning variance would be in a similar vein of the permitting regimes of the Coons and Nolan and Dolan.
It seems like this is a Sheets-type zoning variance law.
I disagree, Your Honor, because what we have is a restriction, a specific restriction that attaches to the property itself.
What's the difference between a rezoning and a zoning variance, qualitatively?
Qualitatively, I think what's important to remember here is that, so in the permitting realm, in the zoning variance realm, you have the government able to make a decision as to whether or not there's going to be, a certain kind of development. But what we have here is an existing restriction. The government's not doing anything to impose that restriction. So when in the variance world and in the permitting world, the government, the action that is being taken actually diminishes the property, the rights in the property.
What I think I hear you saying is that in a rezoning, it's available to everyone who holds that kind of property interest, the restricted property interest. And in a variance, it's a particular individual who's seeking the variance. Is that right?
I think that, no, I think that the way that I would describe it is, so we have this permitting regime. We have a variance regime where the government can take an action, can say, you can have this permit, you can not have this permit. You can have this variance, you cannot have this variance. And what that does is it imposes an actual restriction on the property when the government says no. When the government says, no, you can't have this, or if there's a condition that's imposed on it, the government has then
So you could say you can have this permit if you pay us $20,000, let's say, and anyone who pays it can have this permit. How is that different than this?
And anyone who pays it can have this permit? In the sense, well, it depends on
and then you're
what this
getting
underlying...
a benefit, right? You're granting a benefit by statute to everyone. There's no individual decision there. Isn't that Sheets?
It depends on if... So Sheets didn't address any of this at all.
Well, Sheets didn't address whether it's a taking, but Sheets addressed whether you can do this by legislation, right?
Sheets addressed whether you can do it by legislation, but I submit that that's a different question from what I'm discussing here, which is whether the government action can be thought of as a taking in the predicate sense. So that is...
But you seem to be saying one of the reasons it cannot be is because they did it this way, rather than as an individual zoning variance. But I think Sheets addresses that, doesn't it?
No, Your Honor. So I think that the difference is in terms of what the underlying restriction on the property is. So I think that the question of whether it's being imposed as a legislative rule or not, and I think that that is an important factor in the rough proportionality analysis. I think that is different.
Why is that true under Sheets? I thought Sheets suggests that the fact that it's being imposed broadly does not take it outside the universe of what constitutes taking.
It doesn't take it outside of the universe that constitutes a taking, but it is a factor that can and should be considered. And the concurrence
Under
in
which
Sheets,
of the Supreme Court's cases would you say that's true?
So in Sheets, and in Dolan, I would reference the court to Dolan, which referenced the legislative aspect of whether this was being imposed as an individual adjudication or a legislative scheme. So the difference here is that we're not asking for Nolan and Dolan not to apply because it's being because this was imposed as a legislative act.
That'd be hard to argue after Sheets, I would.
Of course, but I think that what we need to keep in mind is the concurrence in Sheets, both of them, Justice Kavanaugh's concurrence as well as Justice Sotomayor's concurrence, which focused on how narrow that decision actually was.
Well, perhaps one could read those concurrences as noting that those questions remain open, but I guess I'm still not quite tracking what the crux is as to your argument, why this is not a taking. Maybe I'm just not tracking.
So let's set aside, I think, the legislative aspect. I think that
Yes.
what our argument on that is focused on the application of Nolan and Dolan and not the predicate question as to whether there's a taking involved here that would trigger Nolan and Dolan. So I think that the difference here is the underlying restriction, what the government action is trying to do. So I think that Justice Barrett in Sheets, for example,
When you say the government action, do you mean the initial zoning restriction, or do you mean the opportunity now to procure different use through payment of this fee? Which of the two?
I think the opportunity now to, so what is the government doing when it says you have to pay a fee or you have to do this other thing to get a permit? So I think that is, what is the impact on the property from the government decision there, I think is the rub here. And I think that the difference between this case and Nolan, Dolan, Sheets, and Kuntz is that here we have a specific use restriction, undisputed, that pre-existed.
Say it's the same situation here. They're single-family homes, though, same restriction. And as a condition of this legislation, this SNQ, you say, you can do this, you can change the status from residential artist to pure residential, but you have to give us an easement. Is that a taking?
Well, I think that there are two, that goes to the two reasons that I think that there's
No,
not a
but
taking
let's stick
here.
with
The
your first reason. That's
first
the
one-
same benefit you're giving under the same legislation, but instead of saying you pay my arts fee, you say, I want an easement. But under your first reason, as I understand it, that would be okay.
I think that would be okay under this analysis because what is happening with the restriction is that it's not changing based on what the
So
government is
you're
doing.
if you
saying
want to
that-
change it, I get an easement. The government gets an easement to allow you to change it from artist residential to residential.
That would be an extension of this, of the first prong of
That,
our
in your
argument.
view, just so I'm clear, would not be a taking under Nolan, Dolan, Kuntz.
It would not be a taking because of the particular restriction that's being applied here.
I'm not following that. If there's an easement that is required instead of a payment, why is it not a taking under the Supreme Court's case law?
So there's two issues here, I think, Your Honor. So that there's the monetary obligation, which,
Right, but
That's
hypothetically, I'm saying if it's an easement that is required, so let's assume that what the city says is, you can convert, but you have to reserve your first floor for art gallery space, let's say, okay? I hear you saying, I think, that that's nonetheless not a taking, even though it would be an easement, but I'm not clear why.
it's because of what the government action is applying to, how the government action is applying to the property. So, Justice Barrett in Sheets described the interaction between the police action and the takings realm as in-laws and not
I
soulmates.
appreciate that there's not an easement required here, and maybe that's relevant to our determination whether there's an exaction, but I'm still not following, where under the more, Nolan, Dolan, Kuntz, Sheets, is there a clear suggestion that an easement is not a taking? It may be permissible if it satisfies the Nolan, Dolan scrutiny, but how do we get to the point that it's not a taking in any event?
Well, I think that what we have to remember is that Nolan Dole and Coons and Sheets never addressed this particular scenario.
How is it
where
not a
there's-
taking here on this particular regime?
Because of the underlying restriction, Your Honor, because
of the underlying-
because of the underlying restriction that already exists, that predates anything having to do with this case, and because the government
What if
action
it was a
doesn't actually
permit?
change
I'm sorry,
anything
what
with
if
regard
it
to
was a
that.
permit, and you can't build two-story houses, and you need a permit to build above one story, and we pass a law that says anyone who pays us, anyone who gives us an easement can build two-story house. You get a permit. That would be okay or not okay? Because there's a pre-existing restriction on your home, you can't build a two-story house.
If we're assuming there's a pre-existing restriction, then it would be more like the scenario that we have. But what we have in Coons and all of the others is there is no pre-existing restriction.
But let's say
You
my
have-
scenario, there is. You need a building permit to build above one floor. And instead of making you come in and get a building permit, we pass a law that says anyone who gives us an easement through their property can build two stories. Violate taking or not taking?
So I think that's, so we're assuming that there is some kind of restriction on this property that's specific to that property. So,
Whole development zoned, you cannot go above one story. You have to get a building permit to go above one floor. Pass a law that says, hey, that's our rule, but if you give us an easement through your property, then you can build two
well,
stories.
I think what's relevant as to whether that restriction is, whether it's a broad-based, rule in terms of whether there's a permit that has to be sought, or whether it's a specific restriction on the ownership rights of the
And
the
how would
party.
that hypothetical be dissimilar from what's happening here? Because it does sound awfully close.
So I think that the difference is whether there is a specific restriction on the property owner's rights in this case. In this case, there is.
On the property owner's what?
On the property owner's rights. In this case, there is.
Well, I mean,
There
in
is
in this
no-
hypothetical, no one can build above one story.
And there, but in the, I think the hypothetical, as I understand it, is that there is a rule, a broad-based rule that requires the government to weigh in on whether they can build above one story or not. That's not a specific restriction that's attaching to the property itself. It's not.
What
In
does
this
weigh in mean?
case-
It's a zoning restriction. This area is zoned for one-story houses or buildings only. But if you want two stories, you just have to give us an easement and we'll give it to you.
I think the difference is that whether it attaches to the specific property or not. So that sounds like, to me, like a broad-based rule, and what we have here is a stick in the bundle of rights that the property owners never had, Your Honors. So I think that,
Your red light went on. Do you want to just take a moment to, assuming that it is taking or exaction, whether or not it would satisfy Dolan, Nolan
Sure, and I do want to point out that there is an additional
have your red
reason
light
that
on,
there is
so-
not a taking, which I can get to on rebuttal, but in terms of the essential nexus and the rough proportionality, I think that what's important to remember here is that the nexus relationship that the petitioners are advocating for, that's not represented in anywhere in the case law. What we need, and according to this court's case law in Consumers Union and Twin Lakes, and as it interprets Nolan and Dolan, we need a consistent relationship between the stated purpose of the restriction and the condition. And the stated purpose that's from Sheets. This is not a strict standard. Dolan teaches us that it can be a theoretical standard as long as there's an articulable connection between the restriction and the condition. So what we have here is a denying conversion preserves an artistic amenity that has supported the creation of art in the city, and that's exactly what
Do you
the
know
Arts
how
Fund
many
fee
artists,
does.
I think there are 1,636 units, and I saw something here that 1,600 of them are occupied by non-artists.
That is an estimate that the legislators in this case put forward. I don't know whether that's an accurate estimate or not.
Is there
but what's-
anything else in the record to suggest it isn't?
Well, what's important to remember, I think, is that there's no dispute that there are certified artists in these
So if there are
units.
36 out of 1,636 units, what are you preserving?
So I think that what's important to remember here is that, obviously there have been a lot of changes with regard to the use in Soho and NoHo. And I think that, the amnesty has had a role in this as well in terms of suppressing the number of certified artists that have appeared in these, that occupy these spaces. But I think that, there's an assumption here by the petitioners that there is no certified artist market, that there cannot be another certified artist market once these amnesties have elapsed. collapsed. And I think that, that's just not borne out in the record. And I would point out that there is a presumption of constitutionality here, that it is the petitioner's burden to demonstrate that these are, that there is no market for them, that this is totally illusory, I think.
It really seems to me from reading the record that what the fee is trying to do is to do what this restriction hasn't done. It's failed to do. And that I don't see as a nexus, because by lifting this, you're essentially accepting reality of what's on the ground here, but you wanted it to do something different originally when it was done in 1971, and over time it's become evident that it isn't doing that. So the loft law came in, and a lot of them were transferred into lofts, some weren't. Now most, if not nearly all, are occupied by non-artists. So facing reality, you're offering this change, but it isn't a harm from the change, it's a harm from the failure of the project.
I disagree, Your Honor, because I think that assumes that this never had a role in the way that Soho and NoHo has developed. I think that the record shows that there have been thousands of certified artists over the years. There are still certified artists today being certified every year through this process.
Last year?
Granted, there are not that many. A lot of that has to do with the skyrocketing property values in Soho and NoHo, as well as the amnesties play
And
a
that's
role.
under current market conditions. And as I understood it, the increase, the $100 per square foot, was based, I think, although this is unclear in the record, although I think you say it in your brief, on some idea that artists would now be priced out by the increase in property value. But if you're saying they were already priced out, what, again, is the harm you're addressing?
The point is that there are fewer artists that are qualifying for this, certainly. I think that's undisputable. But that doesn't mean that there are no artists. That there are still, to Your Honor's point, this year, I think there have been roughly 23 in the past 5 years that have been certified. There have been, there have been less than 10 over the preceding years per year. But that trend doesn't mean that, again, that there isn't a certified artist market, or that the certified artist market cannot rebound with additional enforcement of this rule. So I think that assumption that this has no role here just ignores the fact that the market study that Your Honor cites definitely shows that there is an ongoing impact with regard to this, with this use restriction, this artist restriction. So,
Where is that in the record, that this increase will price out artists? I know you say in your brief, I think, but is there anywhere in the record support for that?
I don't think we're saying that it will
increase of-
price out all artists. I think that what we're saying is that these two things are flip sides of the same coin. And I think that's a common sense assessment, that the increase in value for either to purchase or rent in one of these units has a direct impact. It's the flip side of the coin for the impact on artists who would want to occupy the space, to use the space for the making of art. So I think that is, evident from the record. And I would point out that the study is not challenged in any way by the petitioners in this case. So I think that is a fair inference to be drawn, because that's just the way that the housing and real estate market works, Your Honor.
Thank you.
Thank you.
Good afternoon, and may it please the court. Chris Kieser for the respondents. The First Department correctly held in this case that the Arts Fund fee could not satisfy either Nolan's nexus or Dolan's rough proportionality requirement. As far as nexus, the record is clear that the Arts Fund is not intended to replace the loss of space.
Can I ask you, suppose there was a $250 fee that was charged for a permit. Would you argue that that was a taking?
Your Honor, the permit application fees typically are not, if they are related to administrative costs, for instance, like something like user fees.
But is related to a nexus question, or, is that about applying Nolan-Dolan scrutiny, or is that about deciding whether it's an exaction? I'm not familiar with cases where courts have said a routine permitting fee is an exaction and then applied the Nolan-Dolan scrutiny. So how do we distinguish those fees if they're permissible, which I take it you think they are?
First of all, Your Honor, this is not a routine permit
I understand, I'm
application.
asking a hypothetical.
But second of all, Kuntz here actually controls the predicate taking analysis. As in Kuntz, the court specifically held that the government's demand for property from a land use
Wait,
permit.
so your view is that any routine permitting fee, let's assume it's reasonable, is an exaction subject to Nolan-Dolan scrutiny?
That's not quite true, Your Honor, because I think that some of them could be considered user fees, such as like sort of a court filing fee, if they are
Okay,
to
so let's
cover
suppose I
administrative
want to, build something and I need a permit to do it under some longstanding law, and the municipality imposes a fee of $250. I'm trying to understand whether your view is that that is an exaction, but it's permissible under Nolan-Dolan scrutiny, or it's not an exaction at all?
I think that a normal permitting fee that's designed to cover administrative costs probably would not cover, or would not implicate Nolan-Dolan.
So let's say it goes 100% above the administrative costs.
I think once
Is it an
you,
exaction?
Your Honor, once you get beyond the goal of covering administrative costs, then you're looking at Kuntz, which talks about how monetary exactions are, that controls the predicate takings question.
But what makes it an exaction, I guess, is the question we're all struggling with. Is it just the fact that it's over and above what a nominal administrative fee would be?
I think that administrative fees, Your Honor, would be justified based on the administrative costs, like a typical user fee.
That's
where-
easy to understand, but what demarcates the transition between a user fee and an exaction?
Well, here, Your Honor, the city is not saying that, that the Arts Fund fee has anything to do with the process of conversion at all. In fact, conversion, really, if you look at the record, is,
But it's a fee, and governments charge fees for things all the time. And they can, they permit, we don't generally hold that governments are restricted from creating fees for certain activities.
that's true, Your Honor, but this is a fee that, on average, is about $250,000.
So if the concern is that proportionality question, right, why don't we think about this as Justice Kennedy suggested in Eastern Enterprises, where my recollection is he said something that may be, disproportionate or extreme in terms of the amount is appropriately analyzed that way and not as a taking.
Your Honor, I actually think that Kuntz is an application of Justice
But
Kennedy's.
in Coombs, there is, I thought, correct me if I'm wrong, there's an alternative. It's either give me your easement or give me some money. Am I wrong about that?
Yes, you are wrong about that, Your Honor. The Florida courts in Kuntz actually were very clear about the fact that it was a monetary exaction and that it was not an in lieu fee.
I thought when I might be misremembering the facts, but I thought that when it initially, during the initial interactions between the local government and the landowner, there was some suggestion that perhaps a larger easement would be appropriate or a monetary payment. Am I wrong about that?
There were some negotiations between Mr. Kuntz and the Water District about maybe the possibility of him being able to develop a smaller portion of his land in exchange for some other.
So your view is that Coons stands for the proposition that money alone, no suggestion of an easement, is a taking? I read, I guess, particularly the concurrences in Sheets as suggesting that's an open question before the U.S. Supreme Court.
Kuntz, in my view, decided that question. That's the reason that the court granted cert in Kuntz, because the Florida Supreme Court had held that monetary exactions did not trigger Nolan-Dolan scrutiny. The court granted cert on the question of.
So what do you make of the concurrences in Sheets then? What are they getting at, if not to suggest that that's an open question?
I think, Justice Kavanaugh's concurrence, as far as the class of properties question, I think that goes to the rough proportionality inquiry of to what extent do you have to defer to a legislative fee schedule, but the predicate question of whether Nolan-Dolan applies to.
Well, I think just Justice Sotomayor's concurrence, I think, says that the question presented here doesn't include the antecedent question whether the traffic impact fee would be a compensable taking if imposed outside the permitting context and could therefore trigger Nolan Dolan scrutiny. Maybe you read that differently, but I read that as suggesting that question is open.
Perhaps that was her view. I think that Kuntz is clear that the reason that the case was even taken in the first place in the Supreme Court was to
Well, it's hard
answer
know-
that question.
It's hard to know why the court takes a case. I assume, I'm not sure that can be dispositive of the scope of its
That was the
ruling.
question presented, Your Honor, because the Florida Supreme Court had held specifically that monetary exactions are not subject to Nolan Dolan. And then when you read the majority opinion in Kuntz, it's clear that it's an application of Justice Kennedy's concurrence from Eastern Enterprises, and the thing that makes the monetary obligation a taking in the exactions context is that it is connected to a discrete property interest. It burdens that property interest.
Do you think that you could have brought a due process claim challenging the amount of the fee as disproportionate to, any reasonable metric?
I suppose that's possible. The standards for due process are different, and that's not how this case proceeded. But I suppose that that's possible. But I think Kuntz applies that Eastern Enterprises standard from Justice Kennedy's concurrence, which is controlling, and that's the connection.
So let me ask you then, if it's about the burden on the property interest, what is the existing property interest that's burdened by this fee?
Well, first I would point out that in Nolan, Dolan, Kuntz, and Sheets, and in fact in any other unconstitutional conditions case outside of the land use context, the government always has the discretion. It's assumed that the government has the discretion to deny the permit. And so whenever a permit is granted, it's an expansion of your rights. For instance, the property owner.
But there's no permit at issue in this case, is there?
Well, the JLWQA residents need a permit to convert, according to the city, they need a permit to convert their use from JLWQA artist housing into general residential.
Right, but this is not, I guess, maybe this is just a question of logic, but they're not telling anyone they have to do that. They're just saying this is how you convert the status of your property.
It doesn't diminish the value. Or do you think it diminishes the value?
No, I think that every permit, and I think Kuntz addresses this at page 605 of the opinion, every permit is extremely valuable to the permit applicant, and that's why the permit applicant would want the permit in the first place. The thing that creates the leverage for the government to actually impose an unconstitutional condition is that the permit is so valuable that an applicant might be willing to pay something far beyond nexus and proportionality to receive it, and that's why Nolan and Dolan exists as a safeguard.
But I'm still struggling with it because you don't have to change the status of your property. You can continue to keep the property with the existing restrictions on it and thereby avoid the fee. No one has diminished the value of your property.
For one, Your Honor, that's true until you want to transfer, bequeath it. So some of these people, when they die, and they want to bequeath it to someone, that's going to happen.
But that would be the same group of people, whoever you could bequeath it or transfer it to would be the same population that you could have before this entire regime was put in place.
Because of the lack of certified artists, the chances of being able to transfer the property to a certified artist are fairly minimal at this point. But I would just point out also.
That's a statement about the economic conditions present in the city, but I don't quite understand how that informs this question.
I think when it comes down to it, it really doesn't matter whether it's mandatory or voluntary, because of course the property owner in Nolan didn't have to build a single-family home.
But if you took the property in the first place with a restriction and you don't have to switch it, why is it different?
Every single one of these cases, Your Honor, involves a permit application which could be denied, and that's the underlying fact about these cases.
Well, but the difference here is that the individuals who would seek this permit, and don't want to pay this fee, had an interest that did not include the tremendous increase in fair market value that they are looking for. That's the difference. right?
I don't think it really is, because in any of these land use cases, the permit is required to do whatever the applicant wants to do. So when the applicant in Nolan wants to build his single-family
Yep.
home, he had to apply for that permit, or else he was not going to be able to do it. And the Supreme Court assumed that the Coastal
Isn't
Commission.
that changing it from from a single-family home to a two-family home? It's changing the essence of the actual interest. The interest is a very limited interest.
I think that any of these permits, I mean, and if you go even to the welfare cases and other unconstitutional conditions cases, the same thing is true, that the interest is not something that one had before, and the permit could be
They got a fee
denied.
simple, I want to change it to a two-family house. They don't have that. They have a very restricted residence.
And I would also point out, as a matter of fact, that
And they can still profit off of it.
the
They
city,
just still have to maintain that restriction on it. What they are looking for is to remove a restriction, and so they say, all right, we finally decided we're going to allow that, we're going to lift the restriction, but we need you to pay this fee to do that.
and this actually kind of leads into nexus and proportionality, because the fee that they're asking
Yes.
the JLWQA residents to pay doesn't have any relationship to what.
Can we go back to Kuntz for just a minute before you turn to that? So Kuntz says that the fulcrum of the case is the direct link between the government's demand and a specific parcel of real property, right? And also says explicitly that it is beyond dispute that taxes and user fees are not taken. So what I'm trying to understand is, why should we not think about what we have here as a user fee? Because it's not tied to a specific parcel of property, right? My understanding is it's true across the district. And if the concern is that it is completely out of whack with anything reasonable, and that may be a colorable argument, that can properly be vindicated as a due process concern.
Your Honor, for each one of these properties, it is tied to a specific property. For each one of these 1,636, they each need a permit.
Not in the way I don't think Kuntz is. That's what I am struggling with. It seems to me that in Kuntz we have, maybe I'm missing something, but in Kuntz I thought we have a specific parcel of property, and initially the municipality, I forget what the exact entity is, you probably remember, but the municipality says, okay, maybe you could give us an easement, maybe you could give us a lot of money, but it's clearly focused on that specific strip. And I thought that what we have here, by comparison, is a broad requirement that a fee be paid that is high for a conversion across all properties that qualify in the district.
Your Honor, the question of whether it applies to one or all properties, that's the ad hoc administrative versus legislative exactions question that Sheets answered. So it doesn't, but in each individual one.
Sheets leaves open, as I think you just said a few minutes ago, the question of what kind of scrutiny might apply and how to treat, how to treat.
That's true, but in this case, we don't need to get to that, because as the record demonstrates on its own, there's actually really no impact of these conversions that can be attributed to the JLWQA residents themselves. And in fact, the city wants the JLWQA designation to go away. That was the whole purpose of the rezoning. The only reason to keep it the way it is so that they could require the JLWQA residents to then contribute to the Arts Fund fee in exchange for a conversion. But the long-term purpose of the rezoning is to increase residential use in Soho and NoHo, and getting rid of the restriction furthers that goal. So the only reason to keep it in place in the first place would be to use it as a means to transfer the cost of this Arts Fund to pay into public art from the public as a whole to these 1,636 residents. And that's why the Arts Fund fee violates.
Well, there is
the
residential
law.
use. I mean, we're not talking about changing a commercial edifice to a residential edifice. It is residential use.
Well, I'd also note that to convert to commercial, there's no fee. And so that's another aspect of this. But
When your red light is on, can you just quickly address the Dolan-Nolan perhaps more directly?
Sure. As far as nexus is concerned, there's no, as the first department correctly held, there's no relationship between what the Arts Fund exaction and artists' housing. And in fact, the record even says the Arts Fund is not intended to replace the loss of space for art in Soho and NoHo.
But what about their point that, yes, housing is part of what these restrictions were intended to achieve, housing for artists, but it was intended to do more than that. The reason you wanted the housing for the artists is to create a nourishing environment where artists could flourish, where artwork and the culture would flourish. And there are other ways to also achieve that beyond creating artist housing. Why isn't that enough?
I think that's kind of the argument the Supreme Court was presented with in Nolan when it came to access to the beach, because if you recall Nolan, the point of the Coastal Commission said it could deny the permit there because the house would obstruct views. And then it said, well, you can have your permit if you give us an easement. The easement didn't have anything to do with views. It had something to do with the broad concept of beach access, but it didn't have anything to do with the specific thing that the Coastal Commission actually wanted to deny the permit for. So here, the reason to deny a conversion permit, to the extent there is one, would be to preserve housing for artists. But the Arts Fund fee doesn't actually help to do that, and in fact, it's not going to be spent in Soho and NoHo anyway. And so when you add that to the fact that, as the first department correctly held, there's no evidence of negative impacts on certified artists, and there's no externalities here to mitigate because the city wants to get rid of JLWQA, and that's the whole purpose of the rezoning, to increase residential use and to sort of get rid of this outdated industrial use compromise from 1971. And so for those reasons, I ask that you affirm the judgment of the first department. Thank you.
Thank you.
So why isn't he correct that it's all about just increasing residential use, not really about supporting artists?
Well, I think that my friend on the other side misconstrues what the purpose of the artist restriction is in this case. He focuses on the housing piece, but that is clearly a secondary aspect of what the restriction was meant to do. If we look at MDL 275 and we look at the City Planning Commission reports and all of the reports leading up to the determination of the fee, it was about preserving the public presence of the arts. It was about ensuring that art and artists could work in the city, could make art within the city. That was the primary purpose, according to the law, under MDL 275 for this restriction. So this is nothing like Nolan.
So how does the fee achieve that goal?
So the fee achieves that goal because it can be used for grant-making purposes, for artistic programming. It can also be used for purchasing facilities, for purchasing artistic space and renovation for artistic space in the Lower Manhattan. So that directly advances the purpose.
The city could have
of-
done that before without designating housing for artists.
I think that what we have to remember, both in terms of the genesis of this restriction as well as what the city is trying to do here, was to balance competing concerns. That's a hallmark of zoning, zoning law and what the city's purposes are here. So when the artistic restriction was first conceived, it was to balance the manufacturing uses and the industrial uses and these vacant spaces that artists were using to create their art. It was not to create a housing program. It was to ensure that the community as it existed then advanced the city's needs, and in terms of what the actual
So housing was
community
secondary,
was
you
there.
just want to create an artist space, and they may live in that space also. Is that what you mean?
That's right, Your Honor. So, and then when we look at the arts fund fee, again, we see this a similar compromise here. We see that there are multiple competing interests. There are people that want to increase, expand artistic restrictions, artistic housing. There are people that want to remove it entirely. And so what the city did here, and reasonably so, was to balance those interests by establishing this fee that provided a pathway to empower property owners to decide whether they wanted to remove this restriction, but conditioning that on the mitigation of the impacts of
But
doing
you don't
so.
dispute that the arts fund fee doesn't create any artist housing, right?
No, it doesn't, and it doesn't have to, Your Honor. What it has to do, it has to advance a consistent purpose. And I would point to this court's decisions in Consumers Union and Twin Lakes. Consumers Union, there was a nonprofit insurer that was converting to for-profit. The question wasn't whether the funds there were going to be used to create another nonprofit insurer. They were going to be used to advance the purposes of the original entity. Twin Lakes, the same thing. You have a $1,500 impact fee for various development lots that could be used for broad recreational purposes, even though the
Your
concern
red
was
light is on.
parkland.
Could we just get back to Kuntz for 1 minute? And I think this discussion with your opposing counsel and Judge Halligan, I think there are things in Kuntz that can support a reading of tying it to an easement, but as I read Kuntz to the end, it seems that that holding is getting broader and broader. And I think, as you were going to say in the very beginning, way back of your presentation, one of the reasons this isn't a taking is because it's a monetary fee. It's the equivalent of a monetary fee. And I don't want to put words in your mouth, but something that along the lines of Kuntz is tied to an easement. But the holding of Kuntz at the very end is, we hold that the government's demand for property from a land use permit applicant must satisfy the requirements of Nolan Dolan when the government denies the permit and even when its demand is for money. Right? Stop. And then Justice Kagan, picking up on the possible implications, I think, of that holding, says, the majority extends Nolan and Dolan to cases in which the government conditions a permit not on the transfer of real property, but instead on the payment or expenditure of money. So clearly, Justice Kagan, dissenting from that holding, which uses broad language and is not tied to an easement, seems to suggest that Kuntz covers a monetary fee to me.
I'll acknowledge that there is some broad language in Kuntz, but I think that what's important is that the majority opinion in that case walked back its determination by emphasizing that the decision had nothing to do with user fees, taxes, and similar obligations. Those were still not takings under the court's analysis. So it was a response to Justice Kagan, a limitation on what the court was saying in this case, that it wasn't actually throwing out all monetary fees and saying that all of them, so long as a property owner had to pay it.
What's the line that we're, sorry, I know your light is on, but what distinguishes one from the other? I think the majority's opinion in Kuntz clearly suggests that there are some monetary payments which should be treated appropriately as a taking, and as you say, with the user fees, some that should not. How do we distinguish between them?
So I think we just looked at Kuntz's reasoning, Your Honor. I think that Kuntz was pretty clear on this point that what was motivating the decision there was this connection with the easement that was being demanded, the dedication. So
But
the in lieu fee.
that's not something, as I think Judge Garcia was suggesting, that is echoed in the concluding paragraph or so of the majority's opinion. So we should just read that into it or across the opinion, I take it?
Well, I think that we have to read the opinion as a whole. There's that aspect, that the concern, this anti-circumvention concern, that the government here was exacting a functional easement by tying the fee to this demand for a larger dedication of property. And I would just, dispute this characterization of the Florida courts. The Florida courts may have said that this was just a monetary exaction. I think Kuntz was very clear that it was not just a
Is a monetary exaction, you would agree, right? The traffic impact fee not tied to a property interest.
There's no indication that there's tied to a property interest
And
in
when
the
that
same way.
went back to California, the mid-level appeals court found that it was a taking.
The mid-level appeals court upheld it based on it satisfying Nolan and Dolan.
So they had to get through the takings part of that first.
They did.
I think they applied Kuntz and said it was a taking.
They did, Your Honor. And so, I think that there is a dispute on this, certainly, but I think that that is a misreading.
And I believe that the California Supreme Court may have vacated that intermediate appellate court decision. I'm not sure. Maybe you know.
I think they disappeared it. I think they said it had no presidential value.
They unpublished it, I think, and
Whatever that means.
Under California law, I think that means it cannot be cited. So, but I think that's.
Less a litigants
But it
only.
suggests there's an open question that is before us.
I think that's Right, to the extent that there is broad language in Kuntz, but I think that the Kuntz's reasoning and the majority's response to the dissent's assertion that this removed all monetary fees or it applied Nolan and Dolan to all monetary fees, the court pushed back on that characterization. So I think the dissent was wrong ultimately in that assessment, because Kuntz made very clear that there were pure monetary obligations and left for another day what that line was going to be. And I submit, based on the court's reasoning in that case, the line is whether it is, if there's a per se taking involved. That's the determination here that was important here in terms of what the fee was doing. It was connected to this, serious infringement of property rights in terms of, dedicating a piece of land for public purposes to the government. So I think that intrusion is what was really motivating the court there, and that's why the fee looked like something different than all of the other fees.
And here,
that
there's
the
no
court
per
said.
se taking, because it's just turning over money, and if you choose not to do that, it's your choice. You keep all the rights you had before the opportunity to convert, correct?
That's
Is
right.
that the way you see it?
That's right, Your Honor. And I think that, there's no takings claim in this case. They've acknowledged that there is, or pardon me, there's no regulatory takings claim in this case. They've acknowledged that it doesn't apply here, but that framework still could be applied in an appropriate case. It's just the same as due process, same as equal protection. Just because the Nolan-Dolan analysis doesn't apply doesn't mean that there are just nothing constraining the government's role in this.
Thank you.
Thank you, Your Honor.